Coming to you live from the Now Media newsroom.
I'm Jim Check. You're watching Now Media with me, Geoff Moyse, Aboriginal law experience in Aboriginal law, 31 years with the 6 different provincial governments, and now practicing on your own. Very experienced in Aboriginal law, and we're talking about the Cowichan land decision. We also talked about the Haida decision and a bunch of other stuff that comes along with that. But one of the things that EBY said just recently, after they held that town hall there in Richmond when the mayor was, EBY said the court promised not to include private lands in the Cowichan title claim, and yet here we are. And that's why he said that he did not inform the private landowners.
Yeah, and I don't know how that would have actually happened unless the judge at some point said to the province's lawyers.
Yeah, because I was puzzled myself.
I'm not going to be finding Aboriginal title over private lands. I don't know. That seems unlikely to me, but I don't know where the Premier's getting that comment from. It seems very unlikely. Certainly the judge would not call up the Premier and say, I'm not going to issue Aboriginal title over private lands, but maybe it was something she said in court.
Yeah, because I mean, he was challenged on that. Why weren't the landowners informed, and so that they could defend their titles? I mean, that seems like a question. I think you and I even discussed, like, why weren't they involved in this if their titles were going to be part, of a decision that they had little to say about?
Absolutely. And if you look at if you look at a lot of the commentary that's happened since Cowichan came down, I'd say a majority of that commentary is about the fact that private owners are very upset that they weren't told that their properties were actually being considered for an Aboriginal title declaration. And if you're not even told, then you certainly can't understand the implications.
And I think that is the critique from the Conservatives as well, saying that they want to stop all these secret negotiations, these negotiations that are happening behind closed doors, that people are just finding out after the fact, and how can they protect their properties. And now that these properties obviously are in limbo for, which could be, I think you and I discussed before, up to 7 years.
So the Cowichan situation is one where, of course, a court has analyzed Section 35 Aboriginal title jurisprudence and has done a lot of court days, over 500 court days, dealing with evidence that was submitted. A lot of that evidence, I think, was admitted under under what would have otherwise been prevented as hearsay, but is not hearsay because Chief Justice Lemaire in Delgamuukw said that sort of information in Aboriginal title context is not considered hearsay, and it is all admissible.
So, I mean, it's very confusing for so many people. Obviously, that Richmond town hall was packed. The mayor was, held that because obviously the landowners there were very scared of what's going on. And then obviously there's even lands around that, because that land title claim originally was double that size, almost like 1,800 acres, and they were awarded about 800 acres.
That's correct. And Cowichan, if I understand correctly, Cowichan are going to appeal the judgment themselves for the opposite reason that the province is appealing, which is they want to get a recognition of title over the other 1,000 acres, which wasn't included by this judge. So they're looking for more. And I have to say that I think there may be another, I was pondering this, and I kind of think that maybe there's another reason that Cowichan put their claim in over private lands. And I suspect, because I've been around this stuff for a long time, I know about Cowichan being in treaty negotiations on Vancouver Island. I also know that most of the land that Cowichan would like to obtain, or any of it that they would like to obtain in a treaty settlement, is actually private land. It's mostly private forest land, because of a historical quirk on Vancouver Island. But I wondered to myself whether the Cowichan wanted to establish a precedent that Aboriginal title is a superior interest in land to private land, not for the Richmond circumstance, but much more to come to the treaty table with that precedent and say, we want private land expropriated on Vancouver Island for our treaty because we hold the superior interest. Now, I may be making this up.
Speculating, yeah.
I'm speculating, but it seems to me, why else would you poke the bear on this stuff and put your claim intentionally over private lands? And it's the only idea I've come up with so far to explain it.
So you think maybe this you're speculating this may be a bargaining chip to kind of like trade off for some of the private lands that they really want?
It's either that or they really did want to make a point and go after the land they thought they were entitled to go after, even if it included private property. So, and it may be that they're looking to see if that can be confirmed by the Supreme Court of Canada, which would be a big win for them and a big loss for private property owners in the province.
Yeah, you say that in you sent a couple of points over, and you said the Supreme Court of Canada, two statements, and I'm going to get this name right. You can help me with Tsilhqot'in, without evidence.
Okay, so what I wanted to mention in this broadcast is that the Supreme Court of Canada made two statements in the Tsilhqot'in decision, which of course was the first Aboriginal title declaration in Canada, in the Cariboo, in the interior of BC. The Supreme Court of Canada made two statements which weren't necessarily part of the sort of the rationale of the judgment, and that made them even more problematic. When I was clerking in the BC Court of Appeal in 1989, one thing that was drilled into me by Court of Appeal justices at the time was, if you become a judge, do not ever say anything in a judgment about something that you do not have evidence in front of you for. Now, the Supreme Court of Canada, that's kind of a rule of judging, I would say. I think the Supreme Court of Canada made a bit of a rookie mistake because they said two things which I personally think they shouldn't have said. One is, when they were trying to characterize Aboriginal title in a way that was different to the Court of Appeal in Tsilhqot'in, the Court of Appeal said it's very specialized to certain sites. It's fishing sites, it's village sites, it's site specific. Supreme Court of Canada was trying to say, well, it's not just site specific, it can be bigger than that. Unfortunately, they used the word territorial. And they were, if you look at Tsilhqot'in itself, the judgment produced Aboriginal title to 2.5% of the territory of that the Tsilhqot'in say is their traditional territory, 2.5%. So it's not helpful that the Supreme Court of Canada creates this supposition that it's territorial title, because as soon as people hear that, they go, yeah, I have title to my territory. Well, not likely, actually. So that was one. The second one, which was, I think, even more egregious, is the Supreme Court of Canada went so far as to comment on the, quote, vast areas of British Columbia which are subject to Aboriginal title. Well, I'm sorry, but I wasn't aware that the vast areas of British Columbia were in evidence in front of the Supreme Court of Canada in Tsilhqot'in. I thought it was the Tsilhqot'in evidence that was in front of the court. So where does vast areas of the province actually come from? And as I said earlier, I think that's a huge judicial mistake to be talking about something that is not in front of you in terms of evidence. And I think those two things have kind of played into a narrative now that Aboriginal title is somehow everywhere. And that narrative, of course, dovetails nicely with Article 26 of UNDRIP, which says Indigenous ownership is everywhere. Everywhere anybody wants to claim it, basically. And so those two things have generated this territorial imperative in British Columbia, which is being used to leverage monetary outcomes, to leverage the notion of Indigenous jurisdiction over those territories, which has never been recognized in Canadian courts to my knowledge. And that's all being leveraged for money and governance power, mostly under UNDRIP, but you can see how I think the mistakes made by the Supreme Court of Canada in those comments has sort of fed into this narrative. Now, the problem with the narrative is it makes it very difficult for anyone to start talking about the treaty process, because the treaty process actually produces title to land. The treaty process does not involve private lands at all. Treaty settlement lands are never established over private lands unilaterally. Private land is only included on a willing seller, willing buyer basis. So the magic of the treaty process is that private land is not, and never has been, on the table. But if you look at treaty settlement lands, they are inevitably 5 to 10% of a typical claimed traditional territory. So if you're running this idea that title is fully territorial, it undermines a treaty process which actually involves creating settlement lands that are probably pretty close to what most people could prove for Aboriginal title under the Tsilhqot'in and Delgamuukw tests. So it's rather ironic. And UNDRIP has really thrown this whole process into high gear.
And that was a choice that the BC government made, was UNDRIP. It's not part of it. You covered that off in the last couple of conversations we've had.
Yeah, that's right. This UNDRIP is an international declaration. It is not binding in international law. And it was a choice that the BC government and the federal government made at the time, BC government in 2019, to adopt UNDRIP, not necessarily directly into BC law, but to say we will use UNDRIP and we will compare all BC laws against it and make sure they conform to it. So yes, it's a piece of legislation in both cases, federal and provincial. It can be undone.
So where does that leave people, though? Like, I mean, like for the property, the landowners right now, obviously, I think you and I've talked before, they're kind of like in limbo. And then we just saw a claim now for the Kamloops and Sun Peaks.
Yeah, that's a very, as people will realize if they've taken a look at the media around that, that's a very, very extensive attempt at an Aboriginal title claim. I personally think it's ludicrous. I don't think there's any way at all that evidence would be able to be established to generate Aboriginal title of that size. Now, obviously, the Secwepem believe differently, believe they can prove the whole area to be Aboriginal title lands. And again, place the claim over Kamloops, Sun Peaks, private properties. Again, I don't know, to poke the bear. You have to remember that at the time they were fighting the Ajax mine, which was a mine that was going in on private land. And so they really didn't have, in Canadian law, they didn't have much say about being able to claim Aboriginal rights and title over private land, because the courts never said that's possible. So I think in respect of that, they went for the big gun solution and just put in a huge Aboriginal title claim over a huge area of the interior.
Yeah, I think you make this point here too, why reconciliation must actually be based on the rejection of UNDRIP and instead based on negotiation of treaties under the BC treaty process. I mean, that's where most of the treaties were settled across Canada. I mean, BC and I think it's New Brunswick or Nova Scotia that have, you know, like if you look at that map, it shows kind of the areas not under treaty, and it's a lot of British Columbia and a lot of Is it New Brunswick or Nova Scotia? I always get the two mixed up.
New Brunswick. New Brunswick has a huge
And lots of
swath.
Quebec too, right? Lots of Quebec as well, right?
Quite a bit of Quebec, yes. So the reason I made that comment is that it seems to me we have now concluded in this province, if you think that we just got a Comox treaty ratified, we just got Kitsim-Kalem ratifying a treaty. I think Kitsilus is coming along next, probably quite quickly. So if you think about it, I worked on the original Nisga'a agreement in the early 1990s and helped to see that through to fruition. So I've been in the treaty game a long time. We have now Nisga'a. We have 5 Manolth treaties. We have Tawasin. We have Tliamin. We have Kitsim-Kalem. We have Comox. Soon to have Kitsilus. There is a model for treaties in this province now. We've done enough of them to know how to do them. But the one thing I would say, and I'll probably get in trouble for this, but I've seen over the years as a fundamental opposition from some First Nation organizations to the treaty process. Fundamental opposition. And if you look at where they are now, pushing the leverage that UNDRIP provides, you can see why they didn't want to subscribe to the treaty process at all, because the treaty process, if you do a treaty, it doesn't give you control over your territory. It doesn't give you all the money from your territory. There are a lot of reasons why certain First Nations have taken the view that treaties are bad, mustn't do treaties, and have denigrated the process, I would say, quite successfully.
Yeah, and I imagine the decision for the Richmond lands emboldens that viewpoint.
It does, but from the point of view of private landowners in BC, it's the opposite. Treaties are the solution to the private land problem because they don't result in treaty settlement lands being determined to exist over private lands. Secondly, they deal comprehensively with claims of Aboriginal title. So once Comox does a treaty, or Tliamin does a treaty, they have agreed in the treaty, which is a constitutional document, that they will not assert or claim or otherwise bring to court claims of Aboriginal title. They will live by the rights and title that are set out in the agreement, and just those. Which, of course, from the point of view of the rest of the public, creates a great deal of certainty. And then all those lands that are in treaty settlement lands, there's a negotiation about whose laws apply, whose laws should have precedence. Sometimes they're First Nations laws. It's all worked out in the context of the treaty. So there's nothing left to resolve. And as I say, Aboriginal title has been dealt with in a way that doesn't result in its extinguishment, but results in it not being assertable after the treaty is done. So not a bad process from the point of view of most British Columbians.
Well, David Eby, Nikki Sharma are appealing this decision. What do you think their chances of success are on that?
I think that the judgment, in my humble opinion, is somewhat egregious, and I see lots of areas of the judgment that I personally do not agree with. So I'm thinking that even in the Court of Appeal, I think that judgment is going to be subjected to a lot of scrutiny. And the Court of Appeal is going to have a lot of people appearing in front of it to tell the court why they think that judgment is wrong. And the only party that I know that's going to be there, unless there are other interveners on behalf of the Cowichan, it's really the Cowichan who are going to be saying, not only is this judgment all correct, it needs to be extended over the other 1,000 acres. I guess my view is that I don't see the Supreme Court of Canada actually being so impractical and ideological as to fundamentally undermine private property rights with Section 35 jurisprudence. They've always said that this is a balancing process and that everybody's here to stay. So basically everything they've signaled would say they won't support this outcome.
Well, I mean, it kind of undermines just the foundations of Canada and the sale of Crown land to private hands.
Private property is the backbone of our society and our economy.
Yeah.
So if it's undermined, even if it's undermined in a way that isn't particularly large scale geographically, this judgment, unfortunately, the judge in paragraph 3551 went so far as to say a precedent from this judgment is that the Land Title Act, which is sections 23 and 25 of the Land Title Act, are the things that give you as a homeowner your indefeasible title and protect it allegedly against the world. She has said, as a precedent of this judgment, sections 23 and 25 of the Land Title Act that do that are not applicable to land over which Aboriginal title has been declared. So if you have private land, like in Richmond, and there's an Aboriginal title declaration made over it, then she has said the Land Title Act doesn't protect you. Now, that isn't just in Richmond, as my colleague Tom Isaac has said time and time again. That's everywhere in BC. She took the precedent and said it applies outside of the Richmond situation. So in the Haida context, I just wrote an article quite recently where I kind of raised the question. So if the EB government knew, and let's go back a step, remember that Canada, BC, and the Haida agreed on Haida Gwaii to establish Aboriginal title to the entire 10,000 square kilometers of Haida Gwaii, which was egregious in its own sense, as far as I'm concerned. But then they extended that over the private lands. They cooked up and I say cooked up, and I mean cooked up, some sort of legal theory which was supposedly going to protect those private lands. The legal theory, actually, if you parse it right down, amounts to the Haida saying in a contract to which the private owners are not parties and cannot enforce. The Haida said, well, you have our word that we'll leave them alone. Now, my question was, of course, once I looked at Cowichan, I said, oh, isn't that interesting? Because Canada and BC and the Haida just slipped into court 1 month after they'd read the Cowichan judgment and asked the court to confirm a declaration of Aboriginal title over Haida Gwaii and the private lands, knowing full well that they had a judgment in Cowichan that said, when you do that, sections 23 and 25 of the Land Title Act do not apply. So then I said to myself, well, for the private owners on Haida Gwaii, I'm thinking that the Land Title Act does not apply to their private properties, which leaves the question of what do they have left.
And the tough part is for the landowners is the province has already sent out this letter that hasn't been made public, but it's been leaked out there that, you know, if you're having trouble getting a mortgage, if you're having trouble getting permits, you know, call us, and we've got a hotline set up. I mean, hotlines are not going to help people much because, you know, like some of those properties are worth a lot of money. How do you get a mortgage? And then so are you just forced into bankruptcy, I guess? Or I guess, when do the lawsuits start against the province of British Columbia?
I would say, you know, there's been a lot of talk about the fact that the private property rights, other than the Richmond lands and the Canada lands, have not been invalidated. Well, you can't take that to the bank, as far as I'm concerned.
That's what I mean. Like, the bank wants a title, right? A clean title.
Yeah. Well, have they been invalidated expressly in a declaration? No. But this judge has just said they have become, they are now defeasible titles. So they don't have the Protection of Land Title Act. So what are they worth?
That's what I'm, yeah. So
And what are they? What's left of them?
Because when you get a mortgage, you're actually giving your title to the bank until you pay it off and they give your title back. But you don't really have anything worth a lot to give them at this point.
Well, it depends on whether the bank thinks that you do or don't.
No.
And if I'm a banker, I'd be looking at that and saying, I don't think I've got much of a guaranteed interest in this property.
Well, I mean, banks are very, I guess, conservative in their, you know what I mean? Like they always want more security than they need. And I don't think that is going to give them much comfort that they could, because, like the landowner, I guess, could walk away, but then the bank is going to, like who owns what here?
Yeah, so my view is that, Cowichan is bad enough, but it is a court case and it'll have to wind its way through the courts. There's been a suggestion by, I think, Dwight Newman in University of Saskatchewan. He's a law professor, constitutional law professor, and a colleague of mine. And he actually posited that maybe a one province amendment to the Canadian Constitution, which is a possibility under Section 43 of the Constitution, a one province amendment that somehow guaranteed private property as against Aboriginal title might be a solution. Well, it's very hard to get that done. Secondly, I suspect that a court might look at that and say, well, you can't do that. You're derogating somehow from Aboriginal title under Section 35. So I don't have a lot of, with all due respect to Dwight, I'm not sure I have a lot of faith in that option. And I noted that Bruce Party came out today, I think in the National Post, and said exactly the same thing. Says, I don't think it'll work.
I mean, a lot of certainty is what's needed in Canada right now for even capital investment, obviously investing in property, because I mean, that's most of us in Canada, that our dream is to own a piece of private property. That's kind of the dream, right? To own a house, some private property or a business or whatever. And if, BC is sitting on literally a mountain of uncertainty right now, considering BC is full of mountains, how does BC move forward? Like, how does this NDP hold it together, and how do they appease landowners? How do they appease the banks and everybody else and capital investors?
A former colleague of mine from the Attorney General's ministry, who is now also retired, he worked on treaties like Comox and Tsilhqot'in. So he knows a lot about the treaty process, and he's a good lawyer. He went into his NDP MLA in Victoria today, and he said to her, basically, what the hell is going on? And she looked at him and she said, are you a lawyer? And he says, yes, I am. I'm a lawyer who has 30 some odd years of experience in this area of law. And she says, well, I'm not going to get into a legal discussion with you then, but we know what we're doing. We're 100% committed. That includes presumably to UNDRIP and everything that goes with that. And we chatted, he and I, later, and I said, it sounds like the MLAs have a script that they're not allowed to depart from. This is great. It's good for British Columbians. It's good for British Columbia. Full steam ahead.
Well, I think there's a lot of British Columbians that will probably echo his sentiments when he walked into that room. What the hell is going on? And
there's been a whole lot of secrecy around all of this. And my personal theory is the reason for the secrecy is because they don't want to poke the bear. And by that, I mean the public of British Columbia. They're trying to do this and hide it because they're absolutely convinced that if the public actually find out what's going on, they're going to be absolutely outraged.
Well, I mean, if most people work their whole lives for that piece of property that they have, they can pass it on to their children. And if it turns out that the Crown didn't even have the right to sell the land, then what do they have?
Right. And when you have the government interpreting the United Nations Declaration to basically confirm that Indigenous ownership is in over 100% of the provincial land base, that they have to do legislative policy work together with the First Nations Leadership Council, which I think a lot of British Columbians would probably be surprised about, and that every project has to be subjected to free, prior, and informed consent. I mean, this stuff isn't the Canadian constitutional structure. This is UNDRIP. And it's just piling on more and more uncertainty. And now we have First Nations actually saying, well, we have jurisdiction over those territories, so you have to abide by our laws. Well, those are laws that have never, to my knowledge, been confirmed by Canadian courts. So how do I know what they are, and how do I know whether I'm supposed to abide by them?
And what if they conflict with Canadian law? Which law do you follow? Do you know what I mean?
That's a very good question, and I think what I've seen happening, I think, is that the provincial government, in some cases, favors the Indigenous law over the Canadian law. And so an example of that, simple example, is when a provincial park gets unilaterally closed by a First Nation, they're probably saying, well, we have a law that says we can do this. And you would think the provincial government would come along and say, where's the evidence of that? Where has it been confirmed by a court that you have that authority? And instead, they sit back and just remain silent.
So what do you have any advice that you can give the people in Richmond and the rest of the people in, Kamloops right now? And, do you pound a for sale sign into your property and hope it sells before something happens? Or do you, you know what I mean? Like what level of panic should people be at right now? Is it 1, 5, 10, or where are we at?
I think a panic level of about 0.1 at this stage. And Tom Isaac has been saying the same thing. Don't get your hair on fire about this.
Okay. What about the people in Richmond, though? They must be at a lot higher than 0.1.
They have every right to have their hair on fire. And all I can say is they need to channel all of the problems that they are facing. Any information about those needs to be channeled into the appeal, either through interveners or through the province. That's the best you can do at this stage of the game. Yeah. I did want to make one more comment, though. I think Aboriginal title at the end of the day probably covers about 5-6% of the province. And, I'll get in trouble for saying that with First Nations who say, well, that's just a lie. It covers 100% of the province. I think it covers about 5 or 6%, which is probably similar to what it would look like if you did treaties everywhere. The difference being that Aboriginal title declarations, of course, produce what we've seen in Richmond, which is if they're over private lands, then we don't know what the effect is, other than instability. But if we were to take that 5 to 6% and put it into treaty lands, we wouldn't have Aboriginal title claims to worry about anymore because they would be contained by those treaties. And private land would not be on the table.
Well, that's not where we're at, I guess. And I guess this has to play out. And do you know if the Richmond landowners, the on private title right now, are doing lawsuits right now? Are they suing the government, or are they just waiting, or what are they doing? Or do you know anything?
Well, my knowledge is probably the same as yours, which is what I read in the media. But I do understand that there's been some movement towards questioning whether they still have to pay Richmond taxes.
I've heard they have to. I mean, that's what I've heard.
Well,
that the city of
that's
Richmond.
not surprising, because I don't think we're at the stage yet where Aboriginal title has taken over those private lands to the extent that Cowichan can now tax them. But I'm also fairly convinced that, if Cowichan went into court tomorrow and said, we want that authority, we want the declaration that we have authority over these lands, I don't see anything in the judgment that would stop them doing that.
And then, if people can't get a mortgage, right now, I mean, there's a lot of talk out there they can't, and even David Eby alluded to that and says, you know, come see us if you can't get a mortgage. I mean, one of the easiest things he could do is they could basically stand behind the properties, right, and back them, but that hasn't been said either.
Yeah, the Jordan Bateman wrote a little piece, I think, on Twitter today. Jordan Bateman, former Taxpayers Federation, Jordan Bateman. And he said something like, he's heard all of this talk about, well, the Crown will just have to compensate. And he says, listen, people, this isn't King Charles we're talking about here, paying this off. We are the Crown. We, the public of British Columbia, we are the Crown. So if anybody's paying to compensate, it's us, the taxpayers.
No, I get that, but you know, and I'm just putting myself in the shoes of the landowner there that has, let's just pick a number, $1 million mortgage, and he goes to the bank, and the bank says, "I'm not giving you a mortgage, and we want our money." Where does he go?
He goes, unfortunately, goes straight to the provincial government.
Yeah, that's what I mean.
And says, guarantee my debts here.
That's what I'm saying. The province has not much choice. I mean, you'd think they would do that already and say, we will guarantee these we'll back the mortgages, we'll guarantee these lands or your property values or something, just even as a stopgap, as a bridge, so that there is some, because I mean, almost impossible to sell as well. Like, you'd have to be a bit of a loon unless you're getting a really good deal on it, like 10% on the property value or something. But I mean, to go and buy and sell it right now wouldn't make a lot of sense.
I think that they are playing it cool right now by not coming out and saying anything about support. Rather than that, they have a civil servant by the name of Christine going around door to door with little pamphlets saying, I'm here on behalf of the government.
Yeah, lots of secrecy. Lots of secrecy, and I think that's what got us here, and they continue down that same road, though.
Oh, absolutely. I'm not seeing any change of direction, and as I say, from that conversation my colleague had with his MLA, the direction isn't going to change. This is full steam ahead.
Yeah, so I guess the only thing people can do is lift the phone and go visit their MLA. I don't know what else.
Well, the most useful thing that could be done in this province right now is for people to demand the repeal of DRIPA. That is absolutely one of the most important things that needs to happen in BC. It's been a dismal failure.
The thing is, it's very complicated, and you've done a great job. I think this is our 4th interview. You've done a great job of explaining, because it's very, very tough to understand for a lot of people. UNDRIP, DRIPA, you know, like the court decisions, section this, section that, and who owns title, and, you know, I mean, it's very complicated. That's why most people trust lawyers when you go and do a land transaction. That's why there is lawyers when they're doing a land transaction. And
it's true. And I spent many years in the provincial government trying to teach civil servants this stuff, and they're no different than the general public when it comes to, you know, comprehending some of this stuff. And I have to say, I've said it before, and I'll keep saying it. This stuff is incredibly complicated, even for the lawyers who practice in this area. We have a lot of questions. So it's just something I kind of like to talk to people on the air, because if it helps even one person get a bit of understanding, then I think it's a good thing to do.
And I think you hit the nail on the head, too, with the MLAs. I don't even think they fully understand what's going on. They may have some talking points in front of them, and they just repeat the talking points and hope the people go away.
Well, when the Minister of Indigenous Relations relays publicly that he had no idea that government lawyers had been instructed to go in and support the Haida in getting a declaration of Aboriginal title from the court on September the 4th, when the minister didn't have a clue, I think that indicates that probably this entire machinery of quote unquote reconciliation is being run entirely from the Premier's office.
So do you think David Eby is the kind of the architect behind all this stuff, and only a few people know the direction of where we're going?
I have sort of personal knowledge that there have been several advisors in the Premier's office with both the Horgan government and the EB government who have a pretty vested interest in seeing this UNDRIP stuff advance. And that's all I'll say. I mean, but these are people of high influence, and they are people who have written in the past about wanting to cause social chaos. Reconciliation won't be reconciliation unless there's pain. So, you know, I can't go further than that, but it's very worrisome.
Yeah, you know, again, you've been very generous with your time, Geoff. I think this is our 4th interview, and you know, obviously, this is not going to go away. Just this one case alone, like you said, might take 5 to 7 years to play out. So there's a lot of uncertainty, and I imagine the landowners are going to start accruing some legal fees as well, as they're going to try and defend their own properties. Whether they sue the government or sue somebody or do something, or at least be able to stand in front of the court and try to defend their property. I'm not sure what effect that will have in the courts, but I think until it gets to the Supreme Court of Canada, and you said they won't do it till it's exhausted here in the BC Supreme Court.
And the BC Court of Appeal.
Yeah, so.
That's right.
Could be a long road to hoe, and even if the Court of Appeals turns it down, I mean, either side's going to appeal the appeal, no?
Yes. Yes.
It doesn't end even if the Court of Appeal overturns its decision, does it?
No.
No.
I suspect not. So the one last thing I'll say is I think that Cowichan has been an inflection point perhaps for the public, because it's got people's attention about an agenda that's been carrying on very quietly and secretly without their knowledge. And the fact that if people are paying attention now, there's a lot for them to understand that is not good about what's going on. And so that's why Tom Isaac, myself, Robin Younger, we keep speaking out, because we're saying, wake up, folks. There's something wrong here, very wrong.
Well, I do thank you for your time, Geoff. And like I said, I'm sure we'll talk many more times as this thing will continue to play out. And we'll see if we can get somebody from, well, I did ask Brenda Bailey about it, and she just said, oh, we're fighting it. That was her only answer when I interviewed the finance minister, because I said it adds uncertainty here. So we'll see if we can get more NDP people in here talking, but like I don't think a lot of them know what's actually going on either. And then, you know, the Conservatives have asked for a pause, but I doubt if there's a pause, right? So,
well, the one other thing I'd say is that if people go to the website of the BC Treaty Commission, if you look on there, what's happened very quietly in the last few years is the federal and provincial governments have convinced the Treaty Commission to create another category of reconciliation agreements where those two governments directly negotiate Aboriginal title rather than doing a treaty. That's what happened on Haida Gwaii. And I think that the notion of one thing that people, I think, should be demanding is that any negotiation of Aboriginal title stop anywhere in the province until we get further into this appeal and we find out what the relationship is between Aboriginal title and private property.
Yeah, I mean, this is definitely not helping the economy of British Columbia and of Canada right now. I mean,
I can't see how it would be.
What's that?
I say I can't see how it would be.
Yeah. Anyway, I thank you for your time, Geoff. You've always been very generous, and very thankful for helping educate the public as to what's going on.
You're very welcome.
And
we'll talk again.
And thank you for watching Now Media.
We don't just report the news, we live here too. We're your neighbors, bringing you stories that matter to all of us. No government funding, no outside influence. Kelowna Now, local, independent. News you can trust.